SJC-12328, WorldWide TechServices, LLC v. Commissioner of Revenue. Thanks.
Good morning, Mr. Rapaki.
Good morning, Chief Justice, Justices. May it please the Court, my name is Ed Rapaki, and I have the privilege of representing the appellant intervenor, Dedham Health and Athletic Complex. This case concerns millions of dollars collected from Massachusetts consumers and businesses, thereafter remitted by the appellee sellers to the Commissioner as either sales or use tax on purchases of optional extended warranties and service contracts. The Appellate Tax Board, on the basis of a detailed stipulation of facts and supporting documentation, and following considerable argument and briefing, agreed with Dedham Health on all of its arguments and concluded that there was no basis in law for the collection of these taxes and that therefore the taxes must be abated. Thereafter, the board entered an order permitting the parties to conduct discovery for purposes of computing the actual amounts to be abated. The taxes at issue were collected during tax periods running from 2001 through 2009. The sellers decided that doing the right thing by their customers was not worth the candle, because pursuant to General Laws, Chapter 62C, Section 37, the sellers would not be able to keep any of the monies that were refunded by the Commissioner. All of the monies, including any statutory interest, would have to be returned to the customers.
So it's not the Commonwealth's money. I know you'll agree with that, but I think there's a suggestion that there might be some other way for the party who actually paid the tax ultimately to recoup this money. Is that true or not?
So both the General Laws 64H Section 3 and 64I Section 3 speak of the monies paid by, well, under 64H Section 3, the sales tax, the customer is required to pay to the vendor reimbursement for the sales tax that is imposed. That amount is to be treated as a debt under the statute. So yes, it is true that customers who wish to get a refund of sales taxes that were ultimately determined not to be owed could proceed, perhaps by way of a monies hadn't received claim, against
How does that work?
the vendors.
A monies hadn't, can they just bring a breach of contract action? How does it work?
Well, it would be a monies hadn't received. Essentially, you would have, it wouldn't technically be breach of contract. Rather, it is the return of monies upon the cancellation of a debt. The debt being tax that was allegedly owed. The monies were paid in the belief that the debt was owed. Abatement has established that.
But that's, in this case, there was civil litigation foreclosed, of course, by the arbitration.
That litigation was under General Laws Chapter 93A,
Right.
and this court held that we were required to allege something other than
Like, this gets
mere
to-
overcollection
Right, this
of
gets,
tax.
I guess, to the due process argument ultimately, right? Whether there's an avenue for the health company
Well,
or the health
certainly-
club to recoup its money that it was wrongfully paid.
Well, no, I mean, due process can, you get due process from the state. You're not entitled to due process from private sellers. Our 93A claim, we were required to allege and prove more than just the mere collection of a tax that was not owed. And this court found that our complaint actually did allege Facts. So it's a different question as to whether or not the defendants would have been liable for damages under 93A Sections 9 and 11. And the altogether different question, whether or not the taxes that were collected and remitted to the state on service contracts and extended warranties should be abated.
What I interrupted you on was, but there's a tax board avenue as well.
Correct.
That's what,
Yes, and so what happened was, in all fairness, what the sellers allege is true. They filed the abatement claims as a hedge against their liability under 93A. And we intervened precisely because a vendor has no interest in really pursuing a refund of sales or use tax because the vendor doesn't get to keep any of the money.
once the motion to strike was allowed, right, did your client also have another avenue in the tax board to seek abatement?
That is our second argument. In other words, we argue that because
I guess I was asking for yes or no.
we were foreclosed from that opportunity. We argue that we did have that opportunity, but we were foreclosed by the board's order. The board said that the motion to strike the withdrawals is hereby denied. The withdrawals having been filed, any pending or future motions are moot, and the board shall take no further action on this case.
And so you couldn't have filed a new request for abatement in front of the tax board?
Well, in fact, the commissioner argues that we do not have the right to file for an abatement. See, the way the process works is you have to first apply to the commissioner for abatement. If the commissioner denies, then you file
No,
a petition.
I understand that. There is an argument, and again, going back to due process, that there was an avenue, and I'm trying to tease out from you whether you agree with that or not.
What avenue we would have had would be to file a monies had received claim in civil court against the sellers. The reason why
And
that
why
is-
couldn't you do that now? Why are you precluded from doing that at this point? It's separate from the abatement process, right? You know how much, we've got a declaration this statute's declared improper, this tax is improper. You're owed $212. What prevents you from bringing a monies had and received claim?
Because the board did not issue a final decision in our favor. The board was interrupted.
Well, they're doing an abatement process. Why isn't this separate? You know how much you paid in taxes, $212 or $245. I know that's not what your major interest is, but I'm just trying to understand, particularly on the due process point, why aren't you protected by this monies had and received? Because it does seem very unfair that the vendor who has no interest isn't going to pursue this. And so you need some way of protecting your client's interest. But if you have another way, then all this abatement process seems to make sense.
Well, first of all, at this point, we are probably foreclosed by
That's a separate issue.
statute of limitations. Second of all, when we file if we were to file a monies had and received claim, we would have to prove that the tax debt was canceled. So we would have to start from scratch again to prove
Couldn't
that-
you just submit the decision, you have a decision of the board,
an interlocutory decision.
interlocutory decision, no one appealed it.
The commissioner has no right to appeal an interlocutory decision.
So
What would happen? So it's not unlike what happened actually in our 93A action. After this court reversed the arbitration order, returned us to Superior Court, the sellers, who were defendants, most of them were defendants in that action, filed a third-party complaint against the commissioner requesting declaratory injunctive relief, essentially saying, hey, look, if we have to pay these customers, then we're entitled to the refund. The commissioner came in and argued, hey, exhaustion of administrative remedies. the place to make the place that the legislature decided these issues should be resolved is the appellate tax board. That's where these cases should go. And the Superior Court judge agreed, saying, yes, that's right. The appellate tax board should decide this. So off we go to the appellate tax board. The appellate tax board decides the legal issue. All that's left is to decide the amount of the abatements. And, the sellers pull the rug out from under us.
Did you have to make a request for findings and report at that point under
No,
Chapter
because
58A?
under Section 13, first of all, it only applies when the board makes a decision on the appeal. The board didn't make a decision on the appeal. You can see the docket entries. They're all marked withdrawn. The board didn't make a decision. But even if the board had made a decision, what the party who is wants to appeal on the basis of either the admission or exclusion of evidence, or whether or not the evidence supported a finding, is required to make a request for findings of fact. Section 13 goes on to say that the board may, in its discretion, also include an opinion. Here, there were no facts at issue. The question wasn't whether or not facts were properly or improperly admitted, or whether or not they supported. The question was, what was the legal analysis that the board adopted? That you find in an opinion. And Section 13 says that's at the discretion of the board whether they want to do that.
Does a settlement require the payment of monies, or can a settlement be one party withdrawing its complaint?
So, General Laws, Chapter 58A, Section 7, grants to the commissioner limited discretion to abate, in whole or in part, a tax liability in two circumstances. It makes reference to 62C, Section 37A, where the commissioner has to make findings that a tax would be too difficult to collect. There's issues with respect to the collectability of a tax. And in that circumstance, the legislature authorizes the commissioner to abate some or all of the tax owed, but there has to be a written agreement that it's public. 58A7 also says the commissioner may abate in full or in part pursuant to 62C, Section 37C, which is concerned litigation risk, where there's a consideration of whether or not the commissioner could possibly lose the whole case. Again, there has to be a written agreement. So neither of that happened here. The commissioner did not abate any tax in whole or in part. The sellers withdrew their petitions precisely so that the commissioner wouldn't have to abate anything. This was not a settlement. This was a unilateral withdrawal by a party after a hearing on the merits. Now, the commissioner and the sellers also point out the board's Rule 21. But again, that talks about in cases of a settlement and talks about docketing entries that are consistent with the terms of the settlement. There was no settlement here. So neither 58A7 nor Board Rule 21 applied. So what was the board supposed to do? It's supposed to apply its Rule 37, which says, when no other rule specifically applies, we apply the procedures that were adopted in equity cases before the rules were enacted. Well, in those cases, just like today, a plaintiff surrenders the right of unilateral withdrawal after a case goes to hearing. Plaintiffs can't just simply withdraw a case. Judges can deny it. They can impose costs. And so...
Even though they've been upfront that that's what they were going to do the whole time.
Look, yes, but look, then the point was, let's stop the hearing, because once the hearing takes place on the merits, then we lose that right. But they didn't do that. Moreover, first of all, they didn't object to our intervening. Moreover, with respect to the hearing on the merits, they said to the Appellate Tax Board, we're not going to argue the merits. The merits really is a dispute between our customers and the commissioner. We were the ones who argued the merits, and we prevailed.
So assume for the moment that you win. What is the order that you're looking for from us, and how will it help persons who are not your clients?
So a remand back to the Appellate Tax Board for final resolution of the abatement appeals. If we, assuming we win that, because it's just at that point, it's a matter of calculation. If the sellers remain a party, then they'll do the, we get discovered that way. If not, under 58A Section 11, we have the right to issue discovery to subpoenas, and the board has the right to issue subpoenas to the sellers to get the data. We'll compute the amounts. The board will enter an order saying that the original sellers were entitled to abatement. At that point,
But hold on, wouldn't, just your client, because you weren't certified as a class representative at the, so you would send it back, you're the only party of interest, right?
but well, not if you agree with me that the board did have discretion to deny the withdrawals and send it back to the board.
So we make Dell litigate.
Correct. And at that point, but whatever, the remedies that were sought is, and the only remedy that the board can issue is an order of abatement. Now, at some point, under Section 37, the commissioner doesn't have to make actual refunds to the sellers unless the sellers prove.
Right, they have to prove that they've already reimbursed the
Now,
customers.
and if they don't, then we'll give them some time.
And they haven't done that,
Right,
so.
and if they haven't done it, at that point, we can bring a class action in the Superior Court, monies hadn't received, where we can bring in the judgment of the Appellate Tax Board saying, this debt has now been canceled and we are entitled to refunds.
So it all leads to another class action seeking the return of the money.
Well, we still haven't-
That's the end game, though. I'm trying to figure out what the end game is here.
Yes, that is the end game if the sellers remain recalcitrant.
It's not the $260?
Because they have, because they don't get the abatement, Dell won't get the abatement unless Dell says we've paid it back to those individuals.
So
And
they
if
get the
if
abatement, they don't get the refund.
Oh, okay.
Abatement
But they
is
don't,
simply
but
the
they're not,
legal
no
order.
one's going to, the DOR is not going to pay them back the money unless they demonstrate that we've paid
Right.
it back. And if they don't do that, they will not get back the money.
And if we need to force them to do that,
then you
yes.
will then
But
have
by the
to
way,
then-
that'll be the first class action, because we were never permitted.
Well, I guess that's right.
But
I guess that's right.
how is that consistent with the other arbitration rulings of this court?
They are,
Which,
yeah.
and I honestly didn't go back and read the two earlier ones, but I thought that we changed our mind, included this had to go to arbitration, right? So how are you getting another class action in Superior Court when I thought that issue had already been decided that this is going to be done through arbitrators?
So this court held that, in fact, the denial of class action relief in an arbitration waiver violated Massachusetts law. It was only after American Express that this court said, American Express, bad decision. We think it's a terrible decision, but we're bound to follow it.
Right, but so
So
we
at
are
that
still, we're
point-
still bound to follow them, right? They're not fallible, but.
Yes,
right.
and so the question will become, one, whether or not our claim for monies had and received is a claim that is covered by the arbitration clauses in the original purchase agreements 10 years ago.
Why wouldn't it be? Why wouldn't that be? And I mean, we're sort of back to the beginning, which is this monies had and received was the claim that's always been your direct vehicle for relief. So why,
The
and
damages under 93A is different.
I get that, but the most direct issue is, the constitutional tax issue, in a sense, is that can your clients recover the tax they paid that they shouldn't have? And it sounds like they can, but they have to do it through this arbitration process.
Not necessarily.
Why not?
Okay. The arbitration ruling applies only to Dedham Health. I mean, remember, that's the whole point of that rigid.
That's the only person you represent too, right?
Right now.
Right, okay, but go ahead.
Right now. So then, Dedham Health, with 3 or 4 others, file a monies had and received claim. Certain of the defendants might very well assert an arbitration clause. So there has to be a determination whether or not that arbitration clause applies. By the way, that
But
arbitration...
it may be dense, but you're buying all of these products through this Dell contract, right? Most of these, there are 3 different defendants, I understand, but the bulk of this is through Dell. Isn't it the same arbitration language going to apply to everyone who bought through Dell?
Yes, the arbitration language, then the question becomes whether it applies to the third-party contractors. But more importantly, the arbitration language directs that arbitration be conducted by the National Arbitration Forum. They no longer do arbitrations. Why? Because the Minnesota Attorney General filed a lawsuit against them, demanded discovery, and rather than respond to the discovery, the NAF said, we'll get out of the business.
So I think we're probably not going to be working right now to decide Dell 3.
Thank you. Thank you very much.
And I think it's for the record, we didn't change our mind. The United States Supreme Court changed our mind. So,
Thank you.
all right,
Chief
thank you.
Justice.
Mr. Shope, good morning.
Good morning, Your Honors. I'm John Shope. I represent Dell and its service contractors. With me, my colleague, Michael Hoven. The Attorney General's office, representing the Commissioner of Revenue, has agreed to divide its time. And so we had initially scheduled 10 minutes for myself and 5 minutes for the Commissioner.
If I can start with this, according to the Department of Revenue, as I understand it, they have determined that you wrongly paid sales taxes or use taxes when you did not need to, and that the cost to your customers is in the ballpark of $10 million. Do you agree with that?
No, I do. I disagree on 2 points. So first off, the Appellate Tax Board made that determination.
Okay.
The Commissioner of Revenue takes the diametrically
Okay, but
opposed
the
view.
Appellate Tax Board, which is, I misspoke, the Appellate Tax Board, which is all that matters right now, unless you were to appeal that, has made that determination.
That's right. The other point, except I think it's very significant that the Commissioner of Revenue vehemently disagrees with the
Okay,
Appellate Tax
well,
Board on that. And I want to correct a statement that Mr. Rapacki made. Mr. Rapacki stated that the reason that Dell and the service contractors are not pressing this is that they don't get the money back. And that's actually not quite so. The reason that they're not doing it is, number one, in addition to the fact that we wouldn't get the money back, it would cost us an enormous amount of money to continue through the process. Not merely the litigation, which is guaranteed to continue because of the Commissioner's desire to appeal, but also the fact that simply processing these abatements would be thousands of man-hours, a huge amount of money involved in that. And as I say, we have a severe doubt that the Appellate Tax Board is right. That basically the Appellate Tax Board, for lack of a better word, blew off the Commissioner's regulation regarding taxation of service contracts. And there's many cases in which this court has held that there should be deference to the Commissioner's interpretation of the tax statute, deference to the Commissioner's interpretation of his own regulations.
Well, that's your position, but basically you're saying the consumers can do nothing to protect their interests.
So that's not what I say. So first off,
Then how can they protect their interests? If that's not what you're saying, how can, if the Appellate Tax Board is right, and you have deprived your customers of in the ballpark of $10 million in sales taxes, how can they obtain justice here?
First off, by the way, it's not 10 million, it's 45 million and counting. So we're
Okay,
probably-
even more so. How can the consumers obtain justice here where they have been deprived, arguably, according to the Appellate Tax Board, deprived of $45 million of their hard-earned money? What remedy do they have right now to get their money back?
So let me step back and speak generally, and then I'll zero in on this particular case, if I may. So speaking generally, because Justice Lowy asked the question about this. All right. So first off, we don't believe that there is a breach of contract remedy, essentially for the reasons stated in the New England Legal Foundation brief. And I think I basically heard Mr. Rapacki agree that there's not a breach of contract remedy. And his initial class action complaint against Dell back in 2003 and subsequent amendments did not include a breach of contract remedy. And I think I also agree that there certainly is there's absolutely no legal remedy by the customer against the retailer on any kind of money had or unjust enrichment theory, unless we were to actually get the money back from the commissioner, and then, contrary to the undertaking that we would have to give to the commissioner in order to get that money, we somehow then absconded somewhere.
But why is that the case? And why is there not a monies had and received, and then you endangered yourself by not pursuing the case then? I mean, I'm trying to figure out, is the cart before the horse or the horse before the cart? Because, yeah, you can't, if you stop the case, so then you can't collect the money, but why is that bar their own monies had and received?
So we basically collect the money as an agent of the Commonwealth. We're legally required, and in fact, the whole regime is set up to pressurize us to collect tax, because the real problem from a general perspective is not that companies are out there over-collecting from their customers. Their incentives are totally to under-collect.
I get it.
The real problem...
You're not it's the state who has imposed a tax that they made you collect.
Exactly right. And that's why we're subject to criminal penalties and interest and all sorts of other things.
Can we just go back to the chief's question?
How did the consumers get their $45 million back?
Okay, well, all right.
I too am wondering, how did the consumers get their $45 million back?
So again, let me answer generally and then answer specifically.
Okay.
Generally.
But you're going to have to answer the question.
I will.
Okay.
But I need an opportunity to answer the question.
I will give you that opportunity.
So the answer to the question is generally. There are a number of considerations outside of the legal process. There's business reputation. If a large number of customers are clamoring for this, there's a motivation for...
So you're suggesting that one way they could do it is by raising a lot of noise?
They can raise a lot of noise, and frankly, this happens on the internet. Now, is it likely to happen as much in a very small amount? No. However, there are also cases where there is a significant amount of tax that is collected, but the party that would receive the abatement is not economically responsible. And for example, we have in the record the Mobil Oil case, where there was a tax on the equipment used in the tank farms out at Deer Island. Millions of dollars. However, the assessed party was not the party that was economically responsible. The economically responsible party got a power of attorney from the assessed party and pressed the abatement at the Appellate Tax Board and all the way up into the appeals court. So when there are larger dollars at stake and it's significant, yes, there are significant incentives and legal means by which economically responsible people who do not bear the legal incident of the tax are able to get the money back. Now,
Specifically?
What's that?
How do you specifically how does the taxpayer specifically? You told us generally. Still waiting
Okay,
to hear about the...
so in this case, if we were to credit, I don't, but if we were to credit what Mr. Rapacki had said in his brief, what he could have done back in 2003, instead of just suing Dell, is he could have filed for an abatement to the Commissioner of Revenue. The Commissioner had the power to grant it, probably wouldn't have because of his views about legal incidents, which I'll talk about in a minute. But the Commissioner could have granted it, probably would have denied it. It would have gone up to the Appellate Tax Board. And if we credit his theories about legal incidence of the tax and so on, the appellate tax board could have given Dedham Health a rebate or an abatement, of the $215.55.
So basically, each of your customers have to go to the appellate tax board to get their $6, $8, $100 in sales tax.
Yes.
That's the remedy you're proposing for your customers.
This court has said, it was ultimately acknowledged by Dedham Health that there's no means of bringing a class action in the appellate tax board. And that's and the thing about the appellate tax board is, and this court has reiterated this on many occasions, that the rules for tax abatements are distinct. They're not covered by the Administrative Procedure Act, Chapter 30A, so a lot of the intervention discussion in Dedham Health's brief is totally inapposite. They are very wooden, and this court has repeated many times that the general equitable considerations do not apply to proceedings in the appellate tax board. And there are very significant public policy reasons why that is so. There needs to be predictability and certainty of revenue once it has been collected. But
I'm still waiting to hear, as far as I can tell, you're telling me that there's no way in God's green earth they're going to get their $45 million back. Is that basically what you're saying?
Yes.
Okay, so that took you a long time to get to that. So basically, your view is you took $45 million of their money, of sales tax money that, according to the appellate tax board, they don't owe, and you are going to do nothing to help them get that money back. Correct?
At this point, given all of the litigation decisions that were made by Dedham Health, that is where we stand. Yes, that is correct.
I mean, again,
Including, by the way, raised judicata.
What litigation decisions?
So, for instance, Dedham Health now asserts that the incidence of the tax is on it. All right? However, if that were so, it could have filed for an application for an abatement itself back in 2003. Chose not to do that. 2011, Dedham Health intervenes in the appellate tax board, does not seek to have any kind of a refund given to itself. All it says is we want to make arguments on the applications that have been made by Dell and the service contractors, even though they've been told at every single stage that if the class action goes away, and they knew that there was a significant risk that would happen, that if the class action goes away, these refund applications are going to go away too. They had many, many opportunities over the space of at least 6 years to amend their intervention complaint to try to assert that they had some sort of an independent right to seek an abatement apart from the applications that were owned completely by us. They chose not to do that. Why? Because what they wanted was the class action. That's what this has always been about.
Yeah, but I think we're not trying to sort blame here. You didn't benefit from incurring this tax. And whether they were doing this as a class action or not, I think we're indifferent to. The issue is, so the state has taken $45 million from a bunch of people, and I think the court is wondering, how does the state make sure those people get paid back? Because it's not, and I think it's in your interest of telling us how the state can right the wrong it did, because I don't think you did the wrong, particularly you're following what the commissioner is recommending. But the idea that $45 million in taxes was improperly collected and there's no remedy raises some issues, right?
Yeah.
So how do you, from a policy or legal, and particularly from a legal perspective, not an economics perspective, is there a right to recover here, and how is it done?
So first off, one thing that we have to understand is that a legal matter, the incidence of the tax is actually on my clients, the vendors.
Right.
And that is crystal clear. There is a statement in the first agricultural case on which...
I think you do a really excellent job of explaining that the incident's been put on you. But the problem is, yes, the tax board the commissioner has an incentive to put the incidents on you because it solves their collection problem. You have been put this burden But the only person who has an incentive to get the money back is cut out of the whole process. And I think that's what's troublesome.
Well, I guess what I would say is a couple of things. So this is not unique, because there are other circumstances, as I say, where the economic responsibility for the tax is not borne by the person who has the legal incidence of the tax. I mean, another example, for example, is real estate taxes, where you'll have triple net leases where it's the tenant that ultimately has to pay the tax, but it's only the landlord who owns the property who has legal standing to seek an abatement. And these leases will often make contractual provision.
Okay, but bottom line is, your clients were charged sales tax or use tax.
Acting at the direction of the Commonwealth of Massachusetts.
But the bottom line is, John Smith, who bought a service contract, paid $200 for it, and you said, oh, the sales tax of 5%, so you owe another $750.
I think what we're talking about here is competing public policies. Yes, on the one hand, it would be nice if we could have perfection in the assessment of each and every tax of $5 or $10 or $1 million. It would be nice to have perfection, and perhaps it would be nice to infinitely litigate some of these fine questions for years and years. I mean, if you look in the record in this case, the briefs go on for dozens and dozens of pages, and the agreed stipulation of fact itself was 56 pages. So there's a lot of resources that get consumed in the process of trying to get perfection. And that has to be weighed against the fact that there is an administrative process that the legislature has set up to deal with taxes, and also have the state recognizing that the big picture problem is not over-collection, it's under-collection. And that's why, frankly, I don't think that we're dealing, candidly, with a huge social problem that is somehow keeping people up at night. Certainly, we're not getting complaints from our customers. Our customers have moved on. They've moved on. And frankly, these monies, they haven't gone to us. They've gone to the Commonwealth. The Commonwealth is providing benefits through all sorts of public services back to people. So I think that it is a false premise that somehow for every single wrong, however minor, there must be a 100% remedy. It simply isn't the case. And in this case, I think there are fair legal rules that basically have yielded the present result.
Okay, thank you.
Unless there are no other questions, I'll sit down.
Thank you. Mr. Hammond?
Good morning, Your Honor. Daniel Hammond, Assistant Attorney General for the Commissioner of Revenue. Your Honor, I think I'd like to start by pointing out that, first of all, the Commissioner is a party only to the proceeding before the Appellate Tax Board, so we can speak only to what the intervener's rights were there. But I'm mindful of the fact that your question, and indeed many questions from the panel, turn on what remedy, if any, do the interveners have here. So I'd like to start just by pointing out, first of all, on the legal matter, both Section 64H, which is the sales tax statute, and Section 64I, which is the use tax statute, are unequivocal on their face that Dedham Health is not the taxpayer here. If this is construed as a sales tax, then it's crystal clear under 64H the incidence of the tax lies on the vendor. If it's
true, but they only get a rebate when they say they've paid Dedham Health.
I'm sorry?
DOR will give a rebate to Dell only after Dell certifies that it has paid the customer that money.
Yes, no, that's absolutely correct.
So, I mean,
but
I know legally it may be the incidence, but that rebate policy indicates that the person ultimately wronged is the sales taxpayer.
Yes, but it's also clear under the law, though, that Dedham Health did not pay a tax here. It reimbursed one of the Dell entities which paid the tax. And that's an important distinction for jurisdiction under the Appellate Tax Board. The Appellate Tax Board, it's a creature of statute, and it's set up to adjudicate abatement requests by taxpayers who petitioned the board saying that the commissioner wrongfully denied my abatement.
Why did they allow the intervention?
Well, again, we have to construe fairly minimalistic rulings by the board, but what the board said when it allowed, and the commissioner opposed the intervention, but when the appellate tax board allowed the intervention, it specifically found that that Dedham Health had a substantial interest in the results of this litigation. Now, it didn't elaborate on that, but I think in context it's fairly clear what it meant. At the time Dedham Health moved to intervene, it was a plaintiff and part of a putative class bringing the Superior Court action under
Right.
93A against the Dell entities. And I think its substantial interest in the litigation was to prevent a scenario where Dell less than zealously prosecuted its abatement request before the board, leading to a board decision saying this tax was rightfully collected, and then allow Dell to import that finding back into the Superior Court action. I think that's what the appellate tax board was talking about when it talked about a substantial interest in this litigation.
Because I guess the big procedural issue is what rights then flow from the motion to intervene that was allowed.
No, I think that's an absolutely critical question, because what it doesn't do is what Dedham Health would have it do, which is to convert it into a taxpayer. That's not what it did. The taxpayer was, and always was, one of the Dell entities here. So to get to the Chief Justice's question, is there a remedy here? The answer is not particularly fulfilling, but the remedies that exist in the context of the appellate tax board are very limited. And they all hinge on Dedham Health somehow transforming itself into a taxpayer for purposes of litigating the abatement claim. And there were options here, none of which Dedham Health actually pursued. But
how could they have, I mean, they would have lost, though. I mean, right? Having somebody do something futile seems, I mean, every incidence is on Dell. So, and you're all sort of pointing us to places that don't work, but I could just, back to the big question. Yes. So $45 million in taxes are improperly imposed. And the people who pay them, there's no remedy for that?
Well, okay, there are a couple places I'd like to
I think
address your question.
At least I don't know what the remedy is yet.
Right.
If the answer is the same as Mr. Shope's, which is sometimes there isn't a remedy, that's great, but I'd like to hear that from the tax, because you've collected this tax.
Yes, but first of all,
and not given it back.
We have collected the tax from Dell, not from Dedham Health, not from any of the other customers.
Right, but Dell collected it. We all know that Dell collected it from real people who bought computers, right?
Yes, no, that's absolutely true. And first of all, let me go right to the substantive question first. We do not agree and never will agree that the interlocutory decision by the board holding those taxes to have been wrongfully collected was correct. And I don't say that flippantly.
No, I understand that. Right.
We had an appellate right that hadn't ripened yet, because the abatement had to ripen into an actual dollar figure abatement before it could have been subject to a report and then subject to appeal. We would have appealed, and we would have appealed, among other things, on the simple ground that there was a duly promulgated regulation in effect through most of this period that addressed this precise situation where there's a bundled transaction of a computer sale that includes, among other things, a service contract, unless the service contract is backed out and separately stated such that the customer knows he or she is paying for the service contract, then it's a unitary transaction and it gets taxed on a unitary basis. Right. It was taxable. So our first answer to that would be, no one has been wronged here. But in terms of remedies before the appellate tax board, there are no class action remedies before the appellate tax board, but there are ways that an individual customer could have transformed itself into or could have stepped into the shoes of a taxpayer here. One, obviously, as Justice Kafker alluded to, is they could have filed an abatement request, which, yes, would have likely been denied by the commissioner, but that is the ticket to entry to a proceeding before the appellate tax board where you are the taxpayer. you could have lost there, and you could be standing here before this court as a taxpayer saying that you were wrongfully denied the abatement. There's also a provision under 64H, Section 3B, which allows a customer to petition the commissioner for a direct payment permit, which would prospectively allow the customer to take over the cause of action for the vendor, to essentially act as the taxpayer. There's also not particularly...
But again, is that a futile gesture because the way the sales tax process works, which is you want the person collecting the tax to do this? Again, I'm just trying to, we're being directed by all these things that you should have done but wouldn't work.
Well, it is largely a prospective remedy because it's a way to step into the shoes of the taxpayer, come before before the ATB and say, this small tax levied on the vendor here shouldn't have been levied and, more importantly, shouldn't be collected in the future. But that's a way that they could have become a quote-unquote taxpayer with rights before the board. I see my...
And you argue that satisfies the due process requirement?
I'm sorry?
And you argue that satisfies the due process requirement?
Well, the due process requirement doesn't come into play until there is a taxpayer, a person aggrieved, that was denied an abatement that's before the board. Once there's a person aggrieved, a taxpayer who is seeking a remedy from the board, they're entitled to the panoply of due process rights, including a hearing.
I mean, ironically, they were a taxpayer.
I beg your pardon?
Ironically, they were the taxpayer in real life. And now they have to be deemed an appellate tax board taxpayer.
In a layman's sense, yes. In a legal sense, no.
Right,
In a legal sense, they paid a debt.
Right, I mean, the ironic thing
taxpayer.
is we have to wave a magic legal wand to get them to be the taxpayer when they were the taxpayer.
Well, again, I'd have to resist the characterization. They didn't pay a tax, they paid a debt.
Right.
Lastly, I know my red light's been blinking for a while now. I do just want to speak very briefly to kind of the threshold issue that we discussed in the brief, which was the failure of Dedham Health to request a report here. I know that sounds like a procedural trap, but it really isn't. And this case kind of points out why.
Is a report a decision on the law, or is it just this fact?
Well, 58A13 says essentially if you don't request the report, you can't raise evidentiary questions, you can't raise factual questions.
But if they had requested a report,
Yes.
would you have been required to explain your legal thought process of why you allowed the withdrawal, or would you have just been?
Well, first of all, I think you mean the appellate tax board.
Yes, I understand.
Would the board have been required?
You're the only person who speaks from the tax perspective for us, so, the government tax perspective.
Okay, I'll take that on only for the purposes of this
Yes, I got
question.
you.
But what would have happened, well, let me back into that answer. The Dedham Health only has a viable appeal here if it can persuade you that on this record, the only thing the board could possibly have done was decided a pure question of law, which is, did Dell have the right to withdraw its appeals or not? What I would suggest is that that's one of many things the board could have decided below, and I think actually a more likely thing the board decided below was that the board let Dedham Health in as an intervener because of the substantial interest that arose from the Superior Court, the ongoing Superior Court litigation, and that at this point, that substantial interest has evaporated. There is no Superior Court class action anymore. The grounds that let me take the extraordinary step of letting them in as an intervener are no longer applicable, and therefore, I'm going to let, as a matter of discretion, I'm going to let Dell withdraw its petitions. That is an implicit factual finding. It's a factual finding about what the board decided at the point of intervention.
That's
and
not
it's
really
a factual finding.
That's more a legal analysis than a factual finding is, that's legal argument, right? I mean, maybe it's legal reasoning, right?
I don't think so. Well, it's at worst a mixed question of fact and law, but it would require the board to explain why were they here in the first place and why is it not inequitable.
And is that what you do in reports?
Yes, yes. The way practice works in front of the appellate tax board, the final decision in a case, and this is obviously a slightly unusual one, usually it's just a straight trial as to the right to an abatement. The decision in an appellate tax board is basically up or down. It's very minimalistic. It basically says the taxpayer prevails or the commissioner prevails. And then the losing party, if it is contemplating an appeal, will request a report, because the report will almost invariably lay out the legal reasoning that the board followed, which is entitled to deference from a reviewing court. All of that got skipped here, and the party that had the ability to remove the ambiguity about what the board didn't do it, and it shouldn't be allowed to benefit from that.
All right, thank you. We'll take our morning break.
Thank you, Your Honor.
Court